After the Joint Committee on Finance tried to gut Wisconsin's open records law right before the 4th of July weekend, there was a lot of interest in Attorney General Brad Schimel's Open Government Summit on Wednesday.
Let's just get right to the elephant in the room. Messing with open government laws is like touching the third rail. I think that experience has been, it's been learned recently. And really this summit has been something that has been in the planning long before what happened just weeks ago.
Officials from Wisconsin's Department of Justice and panels of experts spent the day discussing different aspects of how the open records law is applied and often advocating for various changes.
There might be some low-hanging fruit that if we can reach some consensus that we might be able to go to the legislature with some changes they can make without having to worry about touching the third rail.
Despite this call for open dialogue, the Attorney General quickly became guarded and vague when reporters asked about specifics of the current law.
What kind of guidance are you currently giving lawmakers about releasing personally identifying information such as email addresses, phone numbers, names, and the open records requests that they're currently fulfilling?
Again, that's a matter of attorney-client privilege. They seek our advice.
You should be giving out general guidance, though.
We've been giving guidance in response to specific questions, and I can't
so
talk
like
about
email addresses are okay.
I can't talk about what guidance we give our clients.
So like email addresses for our constituents is okay if it's on an open records request. Is that okay?
We're not going to resolve that issue this morning.
Former Deputy Attorney General Raymond Tafora stated the Attorney General is often in a difficult position when it comes to facilitating open records law.
The Attorney General has a difficult role because he both has the responsibility by statute to potentially advise requesters as to what the public records law means and says, but at the same time he's the attorney for the state. So it's a real management challenge.
Throughout the day, the Attorney General and other experts insisted Wisconsin's open records law needs to be updated to include new technologies. The current law was written over 30 years ago.
We're looking at how we interpret the public records and open meeting laws in light of new technology. That's one of our goals today, to see if we can find ways to have our open government laws address those things more clearly. Hoping to create some cost efficiencies in government without sacrificing transparency, and identify areas where public records and open meetings laws need legislative modernization.
For the MacIver Institute, I'm Bill Osmolsky.